the state of Maharashtra. No quarrel. I've paid it and there is no dispute. Petitioner wrote to the Principal Secretary, Department of Commercial Tax, Government of Madhya Pradesh, and informed the Principal Secretary. The order dated 15/2/2017 passed by the NCLT Mumbai, thereby sanctioning the scheme between JAL and JCCL, that as per the notification dated 3/7, the stamp duty payable has been capped at 25 crore. The petitioner is willing to pay the aforesaid stamp duty. In this representation, the petitioner also highlighted the fact there was another act, my lord, another cess, imposition of 1% cess on the value of property, subject to the instrument under Section 75 of the Madhya Pradesh Panchayat Raj Act, will defeat the object of capping the amount and therefore ought to be relaxed. That was a representation. I made a representation. I didn't bring the document of NCLT Allahabad into Madhya Pradesh. I made a representation to the Principal Secretary. 111, petitioner deposited a sum of rupees INR 32.37 to Mumbai. 19/7/2018, petitioner made a representation to the Honorable Chief Minister of Madhya Pradesh, seeking his intervention on the matter of imposition of Janpad cess at 1% on the sale value of the property. It was submitted that the government may consider issuing a notification capping the same at 1% of the stamp duty. This is again a representation. 6/10/2018, petitioner's representation was accepted by the state government of Madhya Pradesh, and it was directed that Janpad cess was to be collected at 1% of the stamp duty from the petitioner. This is a specific order relating to me. 30/7/2019, Office of District Registrar, District Siddhi, directed the petitioner to submit copies of orders passed by NCLT Mumbai and NCLT Allahabad, pursuant to which it has taken over the unit of JAL located at Bela and Bagwar. This is the crucial data in my submission. 5/8/2019, petitioner by reply submitted a copy of the following. Order dated 15/2/2017 passed by NCLT Mumbai. Order dated 2/3/2017 passed by the NCLT Allahabad. Receipt of payment of stamp duty in Mumbai. Form INC 28 submitted to the Registrar of Companies through the portal of Ministry of Corporate Affairs. Milord, for the second submission of legal, I'm submitting. I brought the document into Madhya Pradesh only on 5/8/2019. And under the law settled by your lordships, this is the relevant date. 23/1/20, the DIG registration Jabalpur. Milord, he is a superior officer to the collector of stamps. DIG registration Jabalpur issued a letter to the registration office, District Siddhi, directing it to recover stamp duty, mark, my lord, on the NCLT Allahabad order, dated 2/3/2017, from the petitioner under Section 19A of the Indian Stamp Act. See, he only mentions the NCLT Allahabad order, presumably because the NCLT Mumbai order had been stamped in Mumbai, and the NCLT Allahabad order had not yet been stamped. It was pending in Uttar Pradesh. In the said letter, the DIG Jabalpur observed that, my lord, much of it is wrong, but I'll read it. NCLT Allahabad, while order dated 2/3, accepted the scheme of arrangement pursuant to which the assets of JAL and JCCL have been transferred to the petitioner. The aforesaid order is an instrument and therefore is liable to payment of stamp duty. The order of NCLT Allahabad instrument has not been registered with the petitioner. Rather, the petitioner has got the order of NCLT Mumbai registered, whereby no transfer of any assets has been effected. Wrong. This has been done to avoid payment of stamp duty. Respectful submission is hopelessly wrong. I was not trying to evade duty. I have paid the stamp duty in Mumbai. I was in the process of paying the stamp duty in Allahabad once it's adjudicated. When I bring it into Madhya Pradesh, I will submit it to the law of Madhya Pradesh. 24/2/20. Pursuant to the directions issued by letter dated 23/1, the Collector of Stamps, District Siddhi, issued a notice under Section 48B, read with Section 40 of the Indian Stamp Act, directing the petitioner to produce the original copy of the instrument order dated 2/3/2017, passed by the NCLT Allahabad. My lord, in the court matters, there is no original copy. It's only a certified copy. And I have certified copies. There is no original copy like a lease deed or a sale deed. There is an original copy and you make subsequent copies. It's either a certified copy or it's not a certified copy. Be that as it may. Petitioner filed a detailed reply on 5/8. State Government of Madhya Pradesh issued a notification dated 25/8/20 in the official gazette, directing collection of Janpat cess at 1% of the imposed stamp duty from the petitioner. This relates back to the acceptance of my representation, serial number 13, on 6/10/2018, previous page. 6/10/2018, they wrote a letter accepting my representation. My lord, formalized it by a notification on 25/8/20. Now, kindly see that order, my lord, so that we can put it out of the way. At page 375, annexure P40. That controversy can be settled. In context of Section 75 of the Madhya Pradesh Panchayat Raj and Gram Swaraj Act, the state government hereby decided that 1% amount of the imposed stamp fees shall be taken from the applicant company, Messrs. Ultrasec. Well, this is not a general order, this is a special order. Now, if I may continue. Petitioner filed an application before the Collector of Stamps, Bulandshahr, Uttar Pradesh, under Section 31 of the Indian Stamp Act for adjudication of stamp duty on the order of NCLT Allahabad. Petitioner informed Respondent 2 regarding the filing of the application before the Collector of Stamps, Bulandshahr, for determining the stamp duty and requested that the proceedings initiated by him by a show cause notice to which I had replied, he stayed till determination of Collector of Stamps, Bulandshahr. I said, you please wait, let the NCLT Allahabad, which is the collector of, which is the order which is produced before the Collector of Stamps in Allahabad, in Bulandshahr, where the immovable property is, let it be decided and then you may continue. I write it on 1910. On 24/10, without further ado, he issued a show cause notice on 24/2. I file a retailed reply by 5/8/20. No hearing, etc. When I move Allahabad or Bulandshahr, Uttar Pradesh Authority, I bring it to his notice on 1910. Please stay your hands. I will get the Bulandshahr order and I'll produce it. 5 days later, he passes the impugned order demanding a total sum of 297 crore. Now it breaks up in the following manner. Over the page. Stamp duty INR 123 crore at the rate of 5% on the immovable property. He ignores the cap. 2. Stamp duty of INR 6 lakhs, the small amount, at the rate of 1% on movable assets. The proviso only applies to movable property, does not apply to movable property. Upkar cess of INR 12,30,000 at 10% of stamp duty.
12 crores, 30 lakhs.
12 crore at 10% on stamp duty. I'm not disputing the 10%. I'm disputing the stamp duty. There's no quarrel about the rate because I had not got a relaxation for that rate. Janpad says of INR 24 crore at the rate of 1% of the value of the immovable assets, he ignores the government notification, 1% of stamp duty. And penalty of INR, what did I do wrong? I brought the document and I offered to pay tax. Why? What a penalty for? Miller, A is hopelessly wrong. B is without jurisdiction. C, the rate is admitted, but the base is disputed. D is hopelessly wrong. It's 1% of the stamp duty. And E is completely without jurisdiction and arbitrary. And its lordship will note as a matter of interest, 137 crore is more than the stamp duty 123 crore. I'll show the provisions below. So this is a hopelessly bad order. And he should have, once he issued a show cause notice, and I'll show you, take your lordship through the show cause notice in the reply. He should have given me an opportunity. This is what I propose to do. What do you have to say? Anyway, writ petition filed to quash the impugned order and hold that the petitioner is not liable to pay stamp duty in Madhya Pradesh on NCLT Allahabad in view of the provisions of the Indian Stamp Act as applicable. That is the preamble. Application filed on behalf of the petitioner to place on record the following. Chartered accountant certificate certifying the net movable and immovable assets of Bela plant and Siddhi plant. Brief note of arguments. This Honorable Court passed the interim order staying the impugned order on 24/10. Now kindly see the interim order. I think it's in your lordship's file. Well, it was contested at that stage. Maintainability of the writ petition was raised and a learned single judge of this court held that the writ is maintainable. And may I read portions of that order? My lord has got the order. Okay. Petitioners have filed the present writ petition challenging the order, 297 crore. It is submitted by learned senior counsel appearing for the petitioners that scheme of arrangement was brought in state of MP on 24/10/2017, and therefore this is the date which has to be considered for levying stamp duty. It is further argued by learned senior counsel for the petitioner there is 25 crore as the maximum stamp duty, etc., etc. Learned senior counsel appearing for petitioners further submitted that collector of stamp is further committed an illegality in ignoring the notification of 27M. Various arguments. Counsel appearing for the state government opposed the prayer for grant of stay on the ground that the petitioner has alternate remedy available to him. Deputy AG relied on judgment passed in writ appeal. It is argued by learned senior counsel that collector has committed an error of jurisdiction and this court can entertain the writ petition on his discretion despite availability of alternative remedy. Learned senior counsel has relied upon the judgment reported in 2018 4 SCC 720. May I read that? Because the next judgment follows that. We may, however, consider a hypothetical case. Supposing the correct value of a property is rupees 10 lakhs, and that is the value stated in the sale deed, but the registering officer erroneously determines it to be 2 crore. In that case, while making a reference to the collector under section 47A, the registering officer will demand duty on 50% of 2 crore, that is duty on rupees 1 crore, instead of demanding duty on rupees 10 lakhs. A party may not be able to pay this exorbitant duty demanded under the proviso to section 47A by the registering officer in such a case. what can be done? In our opinion, in this situation, it is always open to a party to file a writ petition challenging the exorbitant demand made by the registering officer under the proviso to Section 47A, alleging that the determination made is arbitrary and are based on extraneous considerations. And in that case, it is always open to the High Court, if it is satisfied that the allegation is correct, to set aside such exorbitant demand under the proviso to Section 47A of the Indian Stamp Act by declaring the demand arbitrary. It is well settled that arbitrariness violates Article 14 of the Constitution. That is, then subsequent judgment quoted the earlier judgment, and then over the page, paragraph 28, in our view, therefore, the learned single judge should have examined the facts of the present case to find out whether the determination of value of the property purchased by the appellant and the demand for additional stamp duty made by the appellant by the additional collector were exorbitant so as to call for interference under Article 226. Heard the counsel, objection raised by the learned Deputy AG appearing by the state is overruled. This court has discretion to entertain a writ petition despite availability of alternative remedy when question of jurisdiction of authority, violation of natural justice, and fundamental rights are raised in writ petition. Petitioners raise the question of jurisdiction and law. Therefore, the writ petition is admitted for hearing. Meanwhile, impugned order passed by the collector shall remain stayed. This order was passed on 25/11/20. This stay order has continued until this day. This order is not being appealed against. Now, my lord, may I complete this in another 4 or 5 dates? Collector of Stamps, Bulandshahr, Uttar Pradesh, by an order assessed an amount of 92 crore 50 lakhs as a stamp duty payable on NCLT Allahabad order, because the rate is different in Uttar Pradesh. The amount of stamp duty on INR 32.375 crore has already paid on NCLT Mumbai order was deducted from the above assessed duty, and the petitioner was directed to pay the balance. This is according to the law. The law says when you stamp a document, if the similar document or the copy of the document has been stamped in another state, you will deduct the amount. I'll show the section 29. Petitioner paid stamp duty of INR 60 crore as adjudicated by Bulandshahr. Application number 5673 on behalf of the petitioner before your lordship. Order dated 31/3 passed by Collector of Stamp Bulandshahr. Stamp duty certificate dated 25/5 evidencing payment of stamp duty of INR 60 crore. Counter affidavit on behalf of the state along with application to vacate the stay listed before the court when application number 8469 and 5673 filed on behalf of the petitioner were allowed and the documents were taken on record. 2 weeks' time was sought on behalf of the petitioner to file reply to the vacate stay and to file rejoinder. Matter directed to be listed in week commencing from 31/8/21. Interim relief directed to be continued. Following was filed on behalf of the petitioner. Rejoinder I have filed. Reply to the application to vacate stay. Additional reply filed on behalf of the respondent state to the rejoinder. Due to paucity of time, matter adjourned. My lord, the interim applications may not be relevant because your lordship is hearing the final petition. These are the facts. Now kindly see a few documents, just a handful. The show cause notice kindly see item 15.
So page number.
Sorry, I'm sorry. No, just a moment. To the, this is just to register. Item 14, 37/2019. Office of District Registrar directed petitioner to submit copies. That is at page 373. What? It's all in Hindi. There's no translation. All right. Would your lordship permit my learned friend to
Yeah,
read the?
no problem.
I'll read the second one.
No, whatever. I don't know.
उपयुक्त विषयांतर्गत संदर्भित पत्र के तत्सम में से लेख है कि इस कार्यालय में मिसेस अल्ट्राटेक लिमिटेड द्वारा वर्ष 2017 में मिसेस जेपी सीमेंट जेपी एसोसिएट्स के मध्य प्रदेश राज्य में बेला जिला रीवा एवं सिद्धि में स्थित सीमेंट स्टेट्स का अधिग्रहण किया गया है। उक्त संबंध में माननीय उच्च न्यायालय बॉम्बे एवं माननीय उच्च न्यायालय इलाहाबाद द्वारा पारित आदेश क्रमांक 16 दिनांक 15/2/17 2/3/17 दिस इज द एनसीएलटी ऑर्डर्स एवं स्वीकृत स्कीम ऑफ अग्रीमेंट पब्लिक नेशनल कंपनी लॉ ट्रिब्यूनल द्वारा पारित आदेश एवं तदुपरांत रजिस्ट्रार कंपनी को प्रस्तुत स्टेटमेंट के प्रति 1 सप्ताह के अंदर इस कार्यालय को उपलब्ध कराना सुनिश्चित करे। So they asked for the both orders.
Then, my lord, my reply is next page, 5/8/2019. With reference to your caption letter, we are enclosing here with the following documents in connection to acquisition of cement plant, etc., Siddhi and etc. Copy of order of NCLT Mumbai, 15/2, sanctioning the scheme. Copy of order of NCLT Allahabad, dated 2/3. Copy of receipt for payment of stamp duty. Copy of Form NC. So I bring the two documents on 5/8/2019. That is the first. So that